This is Michael Popok, Legal AF. We got breaking news about abortion bans in the South, including a new ruling just today by Justice Clifton Newman of the South Carolina Circuit Court, stopping a new bill that was just passed by the Republican governor, Henry McMaster, who limited abortion with the state legislature's help, led by the GOP, to just 6 weeks. 6 weeks with minor exceptions for life of the mother and for rape and incest, expanding it up to 12 weeks. This on the heels of a law that was struck down by the 2021 South Carolina Supreme Court just in 2021 that was almost identical. What's the difference? The legislature and the GOP Republicans in South Carolina believe they now have the numbers at their Supreme Court, so they can get around what was originally ruled upon by the Supreme Court of the South Carolina in 2021, that a law like this would violate the South Carolina Constitution's right to privacy given to all people, including, in this case, to women. Let me break it all down for you on this particular hot take. Let me give you the players, and we'll talk about the bill and where I think this goes next as the South rises again, or attempts to. It's almost like we got the Confederacy on the move with banning or severely limiting abortion rights and a woman's right to choose throughout the South. Let's start with the judge. Judge Clifton Newman, as I said, a lion on the bench, a leader, somebody who's looked up to by African-American lawyers and judges throughout South Carolina and beyond, along with the rest of the bar. He presided, you may remember, he presided over the most recent trial of Alex Murdaugh, who murdered his family. That Clifton Newman. Clifton Newman has just entered an injunction against the law that South Carolina has passed and McMaster, the governor, has signed, that limits the ability for a woman to get an abortion up to the point of 6 weeks, a point where most people and women, and that's what matters, will tell you sometimes they don't even know that they are pregnant. And that was what the South Carolina Supreme Court back in 2021 was concerned with when the Republicans in the House of South Carolina tried to shove it down the throats and other anatomical parts of women in South Carolina the last time. But what's changed? What's changed is, and you got to sit down for this one, South Carolina is the only state in the union of 50 states where they don't have a woman on their state Supreme Court. Let me let that resonate. 49 other states have at least one woman as a justice on the state Supreme Court, but not South Carolina, where it's all men. In 2021, the one woman they did have who wrote the opinion that stopped the 6-week law back in 2021 from being passed, Kay Hearn, has now retired. She's now 72 and she's retired, and she's been replaced by a man. And when the state Supreme Court in South Carolina in 2021, by a narrow 3-2 vote, struck down the prior 6-week pregnancy ban that was almost identical to the one that got passed this week and signed by the governor, the 3-2 was Kay Hearn, now off and replaced by a man, and John Few. John Few, Justice Few, is who the legislature is aiming for, because even though he voted to strike down that 6-week ban, he did so because he didn't think there was enough research or legislative findings about whether 6 weeks was enough time to give a woman a right to exercise her right to privacy under the state constitution. And now the GOP right-wingers think they fixed that in the bill by also adding a 12 up to 12-week time period for rape and incest and health of the mother to try to get the vote, right? They're lobbying Justice Few through their legislation. And now the first stop on the train is Judge Clifton Newman, who entered an injunction because he wants the state Supreme Court, now all men, to revisit the issue and determine if this ban is consistent with the state constitution's right to privacy for women, yes or no. Judge Newman says no. He needs the Supreme Court to rule. In the meantime, we got chaos in South Carolina on a woman's ability to exercise her right to choose abortion clinics with appointments that are getting canceled and set, doctors who don't know what to do at this current moment. And in the meantime, the clock is ticking on women in that state and their pregnancies. Every day is a day that gets closer to the 6-week ban, or they don't even know that they are pregnant. Now, as I said, we got the Confederacy rising again at this particular moment. On the weekend of Memorial Day, this is where we stand in America. There are complete bans on abortion following last summer's Dobbs decision by the U.S. Supreme Court, ripping away a federal constitutional right for a woman to choose. There are bans in the following states. See if you can figure out what they all have in common. I'll wait. Alabama, Arkansas, Kentucky, Louisiana, Mississippi, Oklahoma, Tennessee, Texas, West Virginia. In Georgia, which is sort of purple, it's 6 weeks. Florida, DeSantis, 6 weeks. South Carolina, we'll see. At the present, it's 6 weeks. If the sponsors of the bill and the governor who are going to defend it can convince the current constitution of the South Carolina Supreme Court, those new 5 men, that they have showed enough legislative findings and research that 6 weeks is enough time for a woman to exercise her right to privacy. Because if you have a right on the books, a constitutional right on the books, but you don't give the person a meaningful opportunity to exercise it, it's no right at all. That's no right. That is the argument. That is the constitutional argument that we're going to have to follow. So we got the first step, right? Judge Newman is not having it. And he stands between a woman's right to choose in South Carolina and the GOP men, the Republican men in South Carolina, and the men, entirely men of the Supreme Court of South Carolina, not having one woman make that decision for them. That's Handmaid's Tale right there. That what I just described. The state that Lindsey Graham proudly calls his home, where he's a senator. That's what we're facing at this moment. And again, as I've said on other hot takes, the conscience of democracy continues to be judges like Clifton Newman and the federal judges that are overseeing all of the Jan 6 prosecutions, indictments, and convictions in the District of Columbia, all those judges. The conscience of democracy, right? I bring it to you on hot takes just like this one, only on the MeidasTouch Network. If you like this one, I don't mean the results. I mean what I'm reporting. We have to keep that clear. Give me a thumbs up here on this YouTube. Leave a comment. I've been known to talk back. We can have a dialogue. And you can follow me on the MeidasTouch Legal AF podcast every Wednesday and Saturday. We do it on YouTube Live. We do audio versions that drop everywhere you can get your podcast from. We're the leading political and legal podcast out there at the intersection of U.S. politics and law. And you can follow me on all things social media at MS Popok. This is Michael Popok, Legal AF.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.